And thanks for joining us here on The Pulse. Lawyers for the 18-year-old Precious Aita have all failed again for the third time in an attempt to serve the Electoral Commission. Now, according to lawyers, two previous attempts have failed because no EC commissioner has agreed to meet them and also to receive the application from the court. Well, the third attempt has been made today, and my colleague James Kwesiavechi has been at the EC headquarters monitoring the ensuing moments when, of course, the lawyers attempted yet again to reach out to the commissioners.
We've been here for almost 30 minutes now. Together, we came to meet the lawyer for the applicant as well as the bailiff. And in our interaction with them, they made us know that they've been here on Tuesday as well as yesterday, Wednesday, in an attempt to serve that contempt application on them, but nothing came out of that. So the third attempt is today. And the lawyer for the applicant is here with me, and so for the 30 minutes, he himself as well as the bailiff have been having some interactions with the police personnel at post here, and some persons who were going in and out of the EC premises. The lawyer joins me to tell us more on what they've been picking from the security as well as those who've been going in and out of the EC premises, and a bit more on that. And so thank you, Counsel, for joining us. I've seen you interact with the police and other persons. What have they been telling you?
So far, the message has been simple, that we have to. Nobody's allowed to come in or out of. They are not admitting anybody into the EC's premises. That is the message we've been getting, and they've told us that if we want to serve anybody, we have to call the person personally, for the person to either come out to come and receive the process. So that is the information that we've been given. We've tried as much as possible to pull strings together so that, because the people that we are serving the EC chairperson herself, Dr. Bosman, and then one Mr. Samuel Tete. Those are the people and it is hard to reach them. So if we're given access, at least the bailiff could have gone inside to attempt service.
What was the reason for not allowing you into the premises?
They didn't offer any reason per se. I think the reason is instructions from above. Nobody is allowed to enter or move out of the premises. So we've been denied access once again.
What that means is that you would have to wait a bit longer to see if you can get access, or if you see any of the EC officials, you would attempt to serve them the application.
Like I said, we are trying to pull our strings and see if we can be able to effect service today. So we'll try our best to effect service today.
What does all of this mean to your application?
It's a contempt application, and the law on contempt application is that it has to be served personally on the respondent who is affected by the contempt application. However, if a bailiff attempts service for more than 3 times and the bailiff is not able to serve a particular court process, the applicants are allowed to apply to the court for the process to be served through substituted service. So
what does that mean?
Substituted service generally means that any means other than personal service. So the court can order that we paste the contempt application on the notice of the High Court Tema, and then paste a copy on their notice board, or serve any person that we meet here, any official of the EC that we meet here. Because we've been trying more than 3 times, and it is now becoming practically impossible to serve the respondents to this contempt application. So if upon several attempts to effect personal service we are still unsuccessful, then our only option would be to apply for substituted service of the contempt application.
Would that, if the court grants you that and you go ahead to do that, would that allow the court to go ahead to hear the substantive issue even in the absence of the EC?
Yes. So substituted service is also deemed as service. Okay. So you can be served personally. So in the case of this particular application, the contempt application, the law is that the EC has to be served personally. Okay. But if upon 3 or more attempts to effect personal service, it is the EC is, excuse my language, evading, or it is becoming impracticable, or to cause unnecessary delay, then the law allows the applicant to come to court to apply for subtest service of that particular process that the applicant is seeking to serve. If that is granted, and we effect the service through the mode of service granted by the court, it is as good as personal service. Okay. Then we can go ahead.
Okay. So how is your client taking all of this back and forth? How is she taking this?
It is a very trying moment for her, but she's in good spirits. We are just encouraging her because nobody should be deprived of their rights to be to vote, or their rights to be enlisted onto the electoral roll. It is just unfortunate that we are here, but.
Okay, I want you to use the opportunity to give us a bit of education on all of this. We know that the original issue that went to court, part of it is about an injunction on the exercise, which shouldn't have been happening. What are the other issues raised in your suit?
Okay, so we have an originating motion before the court. Our client has filed a human rights application before the Tema High Court. The gravamen of our application is basically that the manner in which the EC is seeking to roll out the limited voter registration exercise will put heavy fetters or impediments in our client's right to be enrolled onto the electoral register. That is the gravamen of our case. So I can give you an example. So if a judgment has been entered against you and you apply to, let's say, the High Court for a stay of execution, and the High Court can grant the application for stay of execution. However, it can grant it on such onerous terms that grant is deemed as a non-grant. It is as if it has not been granted, even though in form it has been granted. Because of the conditions attached, it becomes in substance like a refusal. So you are entitled to refuse. So we are not saying that the EC does not have the right to compile a register or do limited registration. We are saying that the manner in which the EC is conducting the voter registration process, puts heavy fetters and impediments in the rights of a lot of people. Okay. And they can't go ahead. They are practically you are denying them of their rights to be registered onto the electoral roll. Okay. So that is why we are in court. So when we filed the originating motion, we filed an injunction application as well. Okay. So the injunction application was served on the EC. However, despite being served with the application, they decided to go ahead. And mind you, if we would cast our mind back on around May of this year, when the NDC, they were doing their presidential and I think parliamentary primaries, Dr. Dufour went to court concerning the voters register, and he was able to secure an injunction application. So he filed an injunction application. Same was served on the EC. The EC restrained her hand. The EC restrained her hand and told everybody that they can't go ahead because they can be cited for contempt. Okay. So why the double standard in this particular case? Okay. So that is why we filed for contempt, and we are just seeking to serve the contempt application.
Which, so far is failing. So what it means is that if by close of today you are not able to serve, tomorrow we should expect you back in court to get that.
If you are not able to serve by close of day, would advise our clients, and then we'll take the necessary steps. Yes.
By the way, has she been able to register yet?
She's not been able to register.
She's not been able to.
She can't register. She can't afford. The distance between where she resides and the closest district office is over 40 kilometers. Okay. It is practically impossible for.
And the question is, although the distance, she's been able to come and file a case in Tema.
No, so this is a pro bono case. Okay. So our firm and a team of lawyers are helping people like that out. Okay. So we are helping those who are disenfranchised, who feel aggrieved by the decision of the NTC. That is basically.
Okay. Yeah. We wish you all the best, and that's counsel for the applicant Precious Aita on their third attempt to serve the contempt application on the Electoral Commission. We'll wait till the end of day to see what comes out of that. Reporting for Joy News, my name is James Aveji from the ET headquarters.
Well, James Aveji continues to monitor the exercise for us, but who's this individual actually aggrieved about the process, and what are her demands from the Electoral Commission? James is back in studio with us, and James, quite a very hectic day it has been for lawyers of this very young lady who we understand is a prospective voter. Tell us about, first of all, who she is, what her challenge is, and what she's seeking from the Electoral Commission through the courts.
Okay, so the applicant in the document, the application she filed in court is Precious Aita. She's 18 years old, and the document reveals that she hails from Afienya. And so from Afienya...
So Afienya, this should be the Greater Accra region.
In the Greater Accra region. Mm-hmm. And she came to file her case in Tema, High Court in Tema. And so two things she's seeking. One is an injunction on the process that started on Tuesday. That injunction, I'm told from the lawyers that immediately that is filed, it prevents the EC from going ahead to do that. And then the substantive case will be heard later. And so those two things she's seeking, that actually a human rights issue, that the proximity we've been all be talking about, that the state and form in which the EC wants to continue with, do the registration process, if should that continue, she as an individual will not be able to partake in that. And so her constitutional right to get onto the voters register and exercise her constitutional right on a voting day would be breached by the EC. That is a substantive issue which would have been gone into later.
Except for this challenge that the lawyers have about reaching the EC or their commissioners. But you know, it beats my imagination. How is this young girl able to file a case in the courts, Tema, right? Move from Afienya all the way to Tema to file this process? And of course, on another hand, she's complaining that, well, I can't go to my district office. It's a question that's come
exactly. That was my point of interest when I threw that to the member of the legal team. And so from his response, he says that this is a pro bono case, which would have meant that even her transportation from Afienya to Tema is taken care of by the lawyers, because she says that she doesn't have the resources to do that. And so her transportation...
So they're doing this free of charge,
all of this free of
without
charge,
any charge at all.
Which would include her transportation from Afienya to Tema, the court to do what she has done. And if she has to appear in court herself, would mean that the lawyers will have to take charge of that as well.
The Electoral Commission and the deafening silence as to why, you know, we simply don't have any response from them on this matter. Is it the case that nobody's in the building as we speak, or it might be the case that, yes, there are people working in, but the security officers do not feel it's the right time to go in? What's the explanation really to that?
Okay, so let me start by painting a picture for you how things pan out today. We know that they've been there on Tuesday. On Tuesday, when they went, they actually called the Deputy Commissioner of the EC, Dr. Sribo.
Okay.
And then they tell us that the response they had from Dr. Sribo is that they, the commissioners, are in a meeting. And so they should go and come back on Tuesday, which was Wednesday, which was yesterday. They went back on Wednesday. They tried reaching them. They couldn't reach anybody. And so when they inquired from the security on duty, they were told that nobody is in the premises. Everybody has gone on field to monitor the registration process, and so there was no one in to serve. And so they left, and then they came back today. Now today, when we got there before the team actually got there, so we walked to them. We spoke to the lawyer on why they were there. They told us why they were there, and then we walked with the lawyer and the bailiff to meet the police on duty. Now, the initial interaction, in fact, when we were getting closer to them, I got a signal from one of the security persons as to why I was approaching them. I told him that I was coming with the two gentlemen, but he signaled me to halt. And so when the lawyer and the bailiff interacted with them, they came back and then they gave us the feedback that this is what transpired. And in my presence, they tried calling the EC commissioners in my presence. The phone goes through and nothing happens. And then I asked the bailiff, he himself, what has he been told? He told me, in fact, there was a woman walking into the premises. So he walked and approached him and then talked to him. He said, she doesn't work there. And so for today, one police officer says that there is nobody in there, so they cannot.
That is the claim, right?
That
there's no one in the EC building,
and so they cannot access. And then another police officer, while we were about leaving, the guy approached him again. The lawyer and the bailiff approached him again, and then he says that the order from above is that nobody should have access into the EC premises. That is what.
That's an interesting point there. No one in the building, suggesting that perhaps no EC official is in the building working today. Mm-hmm. But that will also, could also, I should say, point to the fact that some of these officials are out there monitoring the limited voter registration exercise. Exactly. And you've been monitoring that exercise as well. Day one, some concerns emerging. Is it similar to, for instance, what the case Brisler is putting out there?
Exactly. So day one, when I went to the Ridge office, which is the old EC, coincidentally, the old EC headquarters, mm-hmm. that premises housed 5 different districts. Mm-hmm. So the 4 Ayawaso assemblies and then the Klote assembly as well. Yeah. And so those 5 were there. Now, in my interaction with the number of persons I have interacted with, the registrants, all of them tells me that they were actually assisted to come to the premises to come and register, either an initiative by the assembly member of where they are coming from, or either of the political heads, which would be the member of parliament for the area, as well as John Dumelo, who is the NDC parliamentary candidate.
And this is largely because many of them are unable to provide the transport.
Are unable to get the transportation to come there. And the 2 of them, John Dumelo and the MP, actually confirmed to me that this is what they are doing. And the MP actually stressed that because there are 7 universities in her constituency and members of those universities are quite scattered across the country, she has actually arranged for transportation for them to come. And so, had it not been the assembly member or the 2 MPs, most of them wouldn't have the enthusiasm
the MP and the aspirants.
Aspirants.
Should be putting that in context.
Most of them wouldn't have the motivation to come there, to come and register.
Okay, let's talk about tomorrow. Let's wrap up with tomorrow. What are we expecting from the lawyers of this young lady?
So, the explanation is that they needed to exhaust 3 days of personal attempt to serve this on the EC officials. After that, they would have to go back to court and secure an order of substitute service, if I get that right. And so that would mean that from tomorrow, if they go to the court and the court grants that, they will paste that in the premises of the court and then come to the EC and paste the contempt order, contempt application notice on their walls as well, which would mean that they have duly served them, although they haven't seen them in person. And so from there, then the court can go ahead and hear the substantive issue. I am also told that part of, if that issue should be exaggerated, either or any of the EC officials who have been cited in the case could be arrested, or if it's escalated further, could face some level of jail terms as well. And so from tomorrow, it will be escalated a bit further, no longer looking for them. They'll go for the order of substitute, and then the case proceeds from there.
Okay, grateful. James Ofeji, monitoring developments for RAS here on The Pulse.